You're looking stunning. Can you tell me what inspired your outfit this evening?
So what inspired the outfit is the dress. I wanted something that is bridging a gap between warmth but a bit coolish.
What are you most looking forward to this evening?
This evening, I just want to appreciate the leaders, those who get awards. Just want to learn from them.
Can you take us on the awards tonight? Who do you think's going to walk away with a few?
I can't tell you because I actually know who's winning. But no, they're all worthy winners. So yeah, looking forward to seeing them take their awards.
Welcome to the 6th Annual Africa Construction Law Conference.
I'm here to network. I like the energy. It's so vibrant. I'm looking forward to the sessions. They are going to add so much value to my career and to my employer back in Kenya.
It's going great so far. I've met some pretty amazing people, very smart people, and I'm looking forward to getting on stage myself tomorrow. So it's quite good.
I came to learn more about project management. I manage a practice with a pediatrician. I'm into the medical field, but I'm also looking to go over to the project management career.
I'm not aware of any African country which, within 28 days, can provide evidence that they have money to pay for a variation. So the issue is the procurement framework.
So the architecture is not a problem for the claiming parties. Where we see the disadvantages start to unravel is where the parties themselves start to abuse the dispute process.
I mean, for a contractor whose margin is being threatened, at some point it goes beyond even just margins. The contractor is thinking of survival.
Welcome to the Construction Law Conference.
I'm from James and Doris Legal Practitioners in Zambia, Africa.
From and Luke and Associates attorneys in Gaborone, Botswana.
I'm from Mayor Brown International and I'm based in the London office.
From Bowman's in Joburg.
You're looking stunning. Can you tell me what inspired your outfit this evening?
So what inspired the outfit is the dress. I wanted something that is bridging a gap between warmth but a bit coolish.
What are you most looking forward to this evening?
This evening, I just want to appreciate the leaders, those who get awards. Just want to learn from them.
Can you take us on the awards tonight? Who do you think's going to walk away with a few?
I can't tell you because I actually know who's winning. But no, they're all worthy winners. So yeah, looking forward to seeing them take their awards.
Welcome to the 6th Annual Africa Construction Law Conference.
I'm here to network. I like the energy. It's so vibrant. I'm looking forward to the sessions. They are going to add so much value to my career and to my employer back in Kenya.
It's going great so far. I've met some pretty amazing people, very smart people, and I'm looking forward to getting on stage myself tomorrow. So it's quite good.
I came to learn more about project management. I manage a practice with a pediatrician. I'm into the medical field, but I'm also looking to go over to the project management career.
I'm not aware of any African country which, within 28 days, can provide evidence that they have money to pay for a variation. So the issue is the procurement framework.
So the architecture is not a problem for the claiming parties. Where we see the disadvantages start to unravel is where the parties themselves start to abuse the dispute process.
I mean, for a contractor whose margin is being threatened, at some point it goes beyond even just margins. The contractor is thinking of survival.
Welcome to the Construction Law Conference.
I'm from James and Doris Legal Practitioners in Zambia, Africa.
From and Luke and Associates attorneys in Gaborone, Botswana. I'm from
The drummers, who was drumming with us? Oh no, it's very quiet. I can understand after last night. I saw you on the dance floor. But how are you guys feeling? Do you remember what I said yesterday? The people in the room bring the energy or determine the energy in the room. So thank you. There's somebody who's up bright and early and feeling the effects of her caffeine. So can I count on you guys for one thing? Are you going to bring some energy today? That wasn't convincing. Are you going to bring some energy today? Excellent. We have a rigorous debate that we're going to conclude with later on. But good morning, colleagues. Welcome to the second day of the Africa Construction Law Conference. And as I mentioned, we had a spectacular time last night. And congratulations once again to the nominees, the runners-up, and the winners from last night. Today we move from the structure of projects really to the realities of participation, protection, technology, and more. A reminder that you can still register by the close of business today for the FIDIC training session. As we found out, FIDIC still holds the gold standard, whether you want to create a purple book from the pink book. They still hold the gold standard when it comes to international contract rules. So ensure you invest in yourself and your team and register for that training. Training registration will close by the close of business today. And of course, as Mr. Ngo Martins took us through yesterday as well, they've launched the Construction Dispute Survey. If you have not completed this, give me a wave if you haven't completed the survey. If you haven't completed it, please leave the room. I'm kidding. Only kidding. It takes a mere 7 minutes of your time, as we mentioned last night. Trying to shift an industry on your own is nearly impossible. But collectively, the data gathering and all the rest of it that comes with this survey goes a long way in ensuring that we gather the right data to make informed decisions around your projects. Once again, thank you to our sponsors. Because we're having a little bit of a late start, I'm going to take you through our sponsors in a moment. But we head into our first session. We have an incredible panel lined up behind us, and this session goes to the heart of participation. But I'm going to leave them to take you through this. And at the helm of this discussion, we have Kieran White. He's a senior consultant at Pinsent Masons with over 41 years experience. Doesn't look a day over 25 across South Africa and Africa, particularly in energy and infrastructure projects. His work spans renewable energy, gas to power, green hydrogen, clean technology, transport, water, hospitals, airports, rail, and social infrastructure. It is a great pleasure to have you with us, Kieran. I'm going to hand over to you to take us through the panel and, of course, enjoy a lively discussion this morning. Please give them a round of applause. Are we on? Otherwise, I don't mind sharing my mic. There we go.
Is something happening? Can everyone hear me?
Clearly. I think if you hold the mic just a little bit closer.
All right. Is that better?
Much better.
Right. Good morning, everybody. Thanks very much for that introduction. I like the idea that I don't look a day over whatever you said. So welcome to the session 4, local content requirements and international versus local contractors. So I'm Kieran White. I've been around a bit. I've seen a lot of things, and hopefully I'll be able to share some of that experience, and together with my fellow panelists, make this worthwhile for you. Obviously, we're trying to keep this interactive. There is going to be a Q&A session as well. That's if the panelists don't have too much to talk about going through. So I'd like to just ask the panelists to introduce themselves. We have covered quite a few different areas. We've covered Ghana. We've covered, let's call it Lusophone Africa. I don't know whether you can cover all of those. And then we are in Kenya. We're in Zimbabwe. And obviously South Africa as well. There's 2 South Africans on this panel. There's myself and Tommy to my left. And hopefully you'll find it good, and let's hope you walk away with some new ideas, some experiences that we can share with you. Obviously, the big thing about local content is, just for me anyway, it's there to complement, not supplement government. Government still has the overall responsibility to set the industrialization initiatives of the country and the realization for maybe previously marginalized people or groupings of people. It's not up to contractors, developers, or lenders. They're there to complement, not to supplement. So if I could just start from the very far side, just for the panelists just to say who they are, what they've done, and then we'll get into it once you've got an idea who's up here. Thanks, Paula.
Better? Much better. Okay. If you can hold the mic just a little bit closer so we can hear you.
Sure. Good morning, everyone. My name is Paula Ochango. I am legal counsel in the Business Development Department of Mota Angel Africa, which is a Portuguese company that does construction and engineering projects across Africa, Latin America, Europe, and I am very happy to be here. My expertise is on heavy infrastructure projects, so roads, bridges, railways, airports, and the likes, and I'm happy to share my expertise.
Good morning, everyone. My name is Beatrice Moyo, managing partner at a law firm in Zimbabwe called Mshoriwa Moyo. My expertise really sit at the intersection of construction law, real estate, and corporate law. And I won't bore you too much with my profile. It's on the website, but I'm excited to have this discussion.
Thank you. Good morning, everyone. My name is Ntombi Nyaga. I'm not a lawyer. I'm a civil engineer, but I come here today representing my role as a COO of the Construction Industry Board of South Africa. And I think my role sits at the intersection of construction procurement, industry development, industry performance, skills development, and transformation, driving transformation of the construction industry of the country. And I look forward to actually sharing insights with the panel, the panelists, my fellow panelists, and together with everyone. Thank you.
So, hello everyone. My name is Diogo Campos. I'm based in Portugal, but I've been working for the last 20 years in Portuguese-speaking countries in Africa, namely Angola, Mozambique, Cape Verde, and with a focus on infrastructures and litigation or arbitration in construction and concession projects.
Good morning, everyone. My name's Elizabeth Ashen. I'm a dual qualified lawyer in both England and Wales and Ghana. I'm a partner in the law firm Benziencho Letjen & Kuma in Ghana, and I specialize in infrastructure and real estate projects. I'm a transactional lawyer, so I'm non-contentious, but I'm looking forward to sharing my experiences and being part of this panel. Thank you.
Thank you, everyone. Right, so maybe I'll try and set the scene a little bit just before we get into some of the panelists contributing. So my understanding of local content is that it's a policy tool created by government or state-owned entities to leverage local participation and thereby ensure economic activity, and it should not be seen as creating permanent trade barriers to external contractors, developers, sponsors as such. It's very important, I think, to ensure that there's no excessive or unrealistic local content. From a South African law perspective, we've seen it come up in a lot of the major infrastructure projects, and we see discussions and requirements around ownership, about management, about goods and services, about training opportunities, technology transfer, community involvement, skills development, local supply enterprise, development and employment, and standard support. So it's quite a menu of things that can be created and looked at. The big thing again is it must be there to complement and not supplement and reinforce national development and industrial growth. As we know, in South Africa, that's one of the country's priorities is industrialization and industrial growth to address many of the inadequacies that we have come across. But we must ensure, like many of projects, they're going to be financed either by project financing or export credit financing. So we must make sure that whatever is put in place doesn't prejudice project financing. Most governments are not in a position, or they choose not to be in a position, to invest capital revenue in these projects. We need to make sure that it's bankable. And I know bankable means many things to many different people. But bankability, very, very important, because that's where the money is going to come. It mustn't prejudice delivery risk. And we must make sure that whatever we put in place is at least going to be equivalent from a quality, timing, and cost perspective to what may be gained from exterior sources. And we know in Africa a lot of that will come from the People's Republic of China. Quite difficult to contract against that. Transparency is going to be very important around this, particularly for lenders. As we know, they love a due diligence. And therefore, we have to make sure that whatever procurement regime we follow in any particular project, it must meet compliance requirements. It must build investor confidence and also in the tender confidence itself. So if it's badly designed, local content programs, they can entrench monopolies, stifle innovation, and undermine value for money and overall procurement objectives. We must make sure it's not an overly rigid local content target, as opposed to being formed by principles of reasonableness and proportionality. It must be practical. It must be capable of enforcement. And again, it must meet compliant risks. What we don't want, and we must be mindful, that when putting these local content requirements in place, however we do that, it must not conflict with World Trade Organization, regional trade, treaties, On regional trade, I think particularly about the growing Africa Free Trade Agreement. It must not conflict with compliance requirements, and we must make sure that it's not disguised as some form of protectionism, because that will drive everybody away from your project. What you often find, and for my panelists, just pose some generic questions. In your jurisdiction, is local content contained in law or national policy or license conditions or procurement rules or prescriptive contractual mechanisms by government or state-owned entities? Let's call them the awarding authorities. In your experience, have you encountered local content requirements at odds with project financing, export credit financing, and other issues of bankability? Have you seen entrenchment of monopolies in the form of protectionism? Is it contrary to investment treaties or to the WTO? To get things started, Diago, I did pick on you. Unfortunately, it's not because you're Portuguese. But if I could just pose a question to you, and I'm sure then the fellow panelists will build off that. So many export credit financing projects come with home country sourcing that are often at odds with local content. How, in your view, do you set realistic local content requirements that are well targeted or have the necessary waivers and are structured in a way so the project stays bankable and ECA, export credit compliance, while still delivering real local participation?
Hello. Thank you for this, Kieran. And I do believe there's attention. There's clearly attention because most of the parts of the project, namely in Portuguese-speaking countries, so I'm speaking about Angola, Mozambique, Cape Verde, São Tomé e Príncipe, and Guinea, they need to be financed from the outside. It's totally impossible. Even in Angola, that would be where the financing sector is more developed. It's not possible to finance, not even to have a project finance. The banks don't have a balance sheet strong enough for not even a 200 million euros project, and even less for a 1 billion euro project. It's totally impossible, so they have to be financed from the outside, namely through ECAs, export credit agencies. And the life, it is what it is, and we have to take it from here. We will not change the world. Most of the ECAs, of the export credit agencies, they finance, but there's the other way around. They want to export goods from their own home countries. So they are financing, namely, or mostly below the average. So this comes with not only an opportunity, but also with the demand for outside goods. But on the other hand, you have local content rules. So if you go for the finance, you are obliged to have goods from the outside, and you have also to have local content. There's attention, clear attention. How do you manage this? In infrastructure projects, it's not always easy. Let's be fair. What we usually aim is try to divide, to distinguish between onshore O&M or construction itself. There can be a demand for subcontracting local companies namely small and medium-sized companies, and try to, from the beginning, work with the government on one side and the actors on the other side to know what counts for, because you have to comply with both. And so I think that the first is being clear from the beginning and try to divide clearly what counts for what. And usually civil works or onshore works, they will count as local content, and they can be local content on that. And then offshore supply of goods, equipment, and so on, they will count for the ECA. Of course, this has a problem that if you always do it like this, the development of the country where the project is not being that strong. You are putting on working, so you are creating jobs, clearly, but if you only do it onshore, it's difficult to have an industrialization basis, because the goods, the most sophisticated goods, they come from the outside, and you need them for the ECA. But most of the countries, let's be also truthfully, they will not have the capacity to put forward, namely, big equipment. I'm thinking on big equipment, like a crane. It's not that they are going to be produced, maybe not even in South Africa. So they have to come from the outside. And if you, from the beginning, say which are and which count for what purpose, I think it's good. And then you have to monetize, because it's very easy to agree on something and then do exactly the opposite. So I think that the agreement, it's absolutely relevant that you take it from the beginning, but also during the execution phase, where I think that most of the problems occur, not with the agreement. Everyone is happy when you are signing. Everyone will say, no, we will do this and that, and everyone is willing to do. On the execution phase, it's another problem, and you have to monetize. I think that's the... But you cannot have this monetization. I have been there, where it is so heavy that at a certain point you are not executing an engineering project, but you are making reports for local authorities and for the ECA. So I think that quarterly reports are a good way to do it. If you do it on a monthly basis, normally nothing happens. It's not realistic, and we have to be realistic. I think this is something that I'm not... I was kidding with Elizabeth, saying that transactional lawyers are the air conditioning lawyers, but sometimes I think that we have to take the execution phase also for the transaction, saying, look, this is not realistic. I'm not making monthly reports or even weekly reports. I have seen this. Because at a certain point, you are only looking or only working for compliancing purposes. So I think this is the two key elements. Be clear from the top on the agreement, and then be straight but realistic on monetizing and having realistic, but then with penalties or for non-compliance. On the financing, it's clear that you have penalties. But on local content, sometimes the contracting authority is not that willing to levy a penalty or a liquidated damage. And this is one of the problems that I see.
Thanks very much. Perhaps we could have a quick swing across to the far left, Apollo, with Moto Engel. You often on the receiving end of receiving an RFP in order to proceed with a tender basis, and you've heard a little bit from Diego on some of his thoughts. Do you have something to add to that?
Yeah, I think it would be important for me to just set the stage on the local content requirements in Kenya. Kenya has a very robust and comprehensive national development agenda, which we call Vision 2030. And this vision seeks to make Kenya a globally prosperous and competitive nation by 2030 by promoting sustainable and inclusive growth for its people. So in order to reach these objectives, it also has to create wealth creation opportunities for its people. And to do this, it has set out, in the Constitution, and it reaffirms the position that the economic resources belong to the people of Kenya, and they should be used for their benefit. So it's against this background that we have the local content policy, which sets out guiding principles and approaches. It was formulated by the Ministry of Trade, and it sets out guiding principles and approaches of how these local content requirements can be met, the quotas, the enforcement mechanisms, and things like that. Now, we do not have a set-in-stone local content law as at yet. Every industry has different requirements. For the purposes of this conversation, we have a 30% threshold for certain contractors, 30% local content threshold for contractors holding a certain level of licenses who can do heavy infrastructure projects. And there are also tender requirements generally have preferences for companies that employ local labor, procure goods and services from local suppliers. But it's not set in stone. But recently, in 2025, November 2025, there was the local content bill, which was actually published for public participation. And it's a centralized legislation which sets out significant, criminal sanctions and local content obligations for any foreign company doing business in Kenya. So we have, for example, a heavy fine imposed on the CEOs of companies which do not adhere to these local content quotas. We also have significant financial sanctions to such foreign companies. And a foreign company is defined as a company which is owned and controlled outside of Kenya, doing any kind of business. So there's a 60% requirement to employ local labor force. There's an 80% requirement to, procure supplies from local companies and things like that. So this is obviously under a very heavy debate because obviously of the financial sanctions and the personal liabilities to the directors and the members of management. But it's a discussion that is being had in light of the unemployment crisis in Kenya and the fact that there's a perception that foreign contractors come in, extract profits from the country and don't necessarily transfer the skills. So this is a very relevant discussion in Kenya right now. The bill is under public participation, and that's kind of the background around the local legislation in Kenya. I'll pass the mic to the next panelists, but I think I would also like to talk about the practical realities, especially now removing my hat as a Kenyan lawyer and putting on my hat as a legal counsel in an international foreign contractor. But let me just pause there for now.
That's great. Beatrice?
Thank you, Paula. So Zimbabwe is very much similar to Kenya in the sense that we don't have one unified blanket local content requirement act or statute. It's largely seen in policy. And I think just to address, historically, between 2010 and 2018, Zimbabwe tried to go the hard stance rule way in that our government legislated that infrastructure projects should be owned 51% by indigenous Zimbabweans. And the impact that that had was dire from a capital perspective and a participation perspective. And because of that, Zimbabwe sort of fell by the wayside from an investment perspective and just globally. But since 2018, having realized the negative impact of having rigid local content requirements, the government has introduced a more nuanced and flexible approach regards local content. So the restrictions that the government previously instituted have all been scraped away, especially as they apply in the construction and infrastructure sector. Zimbabwe is open for business. That's the mantra we say in Zimbabwe, and welcomes foreign participation. There's certain industries where there's stricter local content requirements, like your mining, but by and large in infrastructure and real estate, there's nothing strict in terms of the letter of the law about what the thresholds, like she mentioned, or the quotas. There are certain reserved sectors that are reserved for indigenous Zimbabweans, but for the purposes of this discussion, none of them apply. So there's lots of opportunity in Zimbabwe at the moment. There are negatives and positives, and I think we'll discuss that as we move into that. But just to highlight that Zimbabwe has moved from a more stick approach, which it tried and it failed, to a more carrot approach. So not to say there's no incentive to utilize local resources and skills and to train, but the law has taken an approach where instead of penalizing individuals and companies for not using locals, it incentivizes through your licensing reporting. So as a foreign investor, you have to go through our Zimbabwe Investment Development Agency. And when you apply for that investment license, they require you as the investor to do your own local content sort of plan and strategy and highlight how you will achieve those certain milestones. And the goal is that you report and achieve, recognizing that you shouldn't just come into Zimbabwe and commercially extract, but add value to the society. There's no strict penalty in terms of whether or not you follow it. Not to say that, obviously, it's to the advantage of the company and the society that you operate in to give back to the community. What we do see, like I said, it's in policy, not so much in law, but from a political and commercial perspective as well. We see that the companies that come in and try to align with global local content requirements tend to do better. From a procurement perspective, as was mentioned by Paula as well, the procuring entities, which is largely government, usually have evaluation criteria that's better for companies that show or illustrate their desire to comply with local content requirements. So it's a point-based system and a monitoring and evaluation system, and not so rigid. So that's what I'll say for now before we get into the positives and negatives of whether the system that Zimbabwe's taken is better or worse.
Kieran, can I just add something? It's Angola has made more or less the same. It had a rule that still applies to some sector, but it had a general rule that a company incorporated under Angolan law by a foreigner had to have an Angolan partner. That the law didn't say that, but it was a free carry-on usually, and has stopped because it has realized that that was turning not into development, but into paying rent always to the same people. And I think that's a way, I think they were correct on doing that. Still exists in some sectors, of course, but not as a general rule. Now a foreigner can have a 100% company incorporated under Angolan law because it simply didn't work. And we have to maybe understand that there are some free carry-ons that really do not give nothing to the country, otherwise than paying a rent. It's paying another tax. To be honest, I didn't know about Zimbabwe, but it's the same. They realized that it had to go other way, and they have stricken other local content rules but not this one. And this has made also an income of capital, of course, because it's very difficult to say to an international company, go to Angola and free carry on a number of people that you don't know for anywhere, and what are they putting on the company? Very little. There's other ways, and I think that we have to understand that.
Can I just say from a Ghana perspective, Ghana is quite similar to the other countries. Local content and local participation is very key for the Ghanaian government, and it varies across the different sectors. I think we'll discuss that a bit later, but generally speaking, it varies across the sectors. I would say petroleum, upstream petroleum, mining, there are some provisions there relating to local content and local participation. But for example, our construction industry has no local content provisions or law regulations whatsoever, totally unregulated. However, where you are doing a government project, then you will find that there'll be some requirements, whether it's a public procurement or it's a public-private partnership. There are provisions in the laws relating to local content and local participation. I think the initial question was in terms of the relationship between if you have financing, let's say ECA, and then you have to comply with your local content laws. As I said, Ghana, we do have local content regulations and laws for specific sectors, but clearly where the financing is coming from outside of Ghana, and it mandates the requirements of the goods and services to be provided for a particular project, the regulators are generally quite amenable, because they want to make sure that the project is bankable and that the financing isn't withdrawn. So generally speaking, you will find that the conditions that are imposed by ECAs are complied with. Of course, also trying to ensure that you do comply with any local content requirements.
Thanks. Elizabeth?
Yes, if I may come in. I think from the South African perspective, local content is actually embedded in our national policy and our procurement, public procurement laws. This stems all the way from, I think, the foundation of it all is our constitution, I think, which I think somewhere in some of the sections, it actually promotes focuses on advancing previously disadvantaged individuals in procurement. And we also have on our side what we call our Public Procurement Act, which is Public Procurement Act, I think the current one is 2024, where it sort of starts stipulating what the provisions for local content in procurement, where minister has to designate some sectors or subsectors which are for local production. And of course, we've got technical standards that also speak to that in terms of our South African national standards, which sort of somehow highlight how to define it, how to define local content and what is local content. And then also, I think somehow similar to the other countries, is that in our tendering, in terms of our contractual mechanisms, we sort of also have accommodations there, in the sense that, for instance, you'll find that in projects which are civil engineering or building focused, you will find that, for instance, still cement and other products have to actually have a particular minimum threshold that must be met. And you find that in terms of bids then needs to respond to that and indicate how they are meeting that. And failure to that, the bid will then be considered non-responsive. And maybe if I can just bring it home to the CIDB environment, where we regulate the construction industry of the country, we are are not, we are actually, we do support foreign companies coming into the country, but our interest also is to actually ensure that we protect our local contractors. So you find that we will sort of still grade them in a similar manner as our local contractors, but we are now shifting towards limiting how they actually play in the space, in the sense that we will then, we are looking at only limiting them at projects at grade 9, which is our top tier level in terms of our grading of our contractors. And that is where they can actually, that they will be operating in. And these are sort of projects of more than 130 million. A project, and with an intention that we're looking at foreign companies coming in with a special skill that probably might not be in the country, or technologies, and we are also encouraging joint ventures coupled with that, with specific, obviously, developmental outcomes to ensure that there's that transfer of skills to our local contractors. And we've got other vehicles as well, where we are looking at how do we further develop the construction industry using the local content mechanism and foreign companies as well. I'll end there for now.
Oh, that's great. Thanks very much, Ntombi. So just some takeaways that I've picked up from what some of my panelists have said. I think one size doesn't fit all. So what happens in Kenya may be applicable to South Africa or not. So just we need to all be mindful of what's required, and in order to do that, you've got to have a very good grasp of the legal framework. For lawyers, probably a little bit nervous about lots of stuff gets hidden in policies, because policies go through a different sort of induction compared to, say, change in law. But certainly, because of the changes that could come through in policy, as well as in legal law themselves, then you've got to make sure, for example, there's a change of law provision somewhere in your contract, so that when changes come through, even if it happens to be in localization, it can be passed through. Because what we're trying to achieve here is to come away with a project that's going to be affordable, and affordability is going to be also equated to tariff, and tariff is all created by the financial model associated with a particular project. Some of the challenges that I've seen when this happens, particularly around ownership, it's whether the, let's call them the minor equity holders, do not have the balance sheet that the major equity holders have, and therefore they have to raise equity finance so they can convert into, they contribute. Alternatively, sometimes if you're involved with communities, they want a free carry, so they receive equity, but they don't pay for it. It's a free carry. And then, of course, you've got the lenders in the sidelines, which are wanting to make sure that everything is known and everything is secure, and they don't want to see any leakage. And if you're going to bring in localization equity ownership, if you're tied up into financing, the lenders won't let money out until the debt has been squared away. Now, that doesn't really help local communities, because it means they're only going to see a dividend flow maybe 10 or 15 years later, and that doesn't help them at all. So in South Africa, they've developed a thing with the consent of lenders, like a trickle of investment is allowed to be passed through, so that at least there's something to be seen. So the lockup of dividends also needs to be considered. And in my experience, no matter what the rules are, provided that the rules are clear and they are standardized and everybody understands them, developers, sponsors, contractors, they can get their heads around all this. They just need to know what the rules of the game are. What they don't want is uncertainty where things change as you go along, whether it's during a construction phase or operational phase. Because that then, sometimes, because the tariffs are set and there's not a robust change of law, there's only one place where these changes can go to, and that's to the shareholders, which is going to impact their investment ratios. So those were just some things that I took away from my colleagues on the panel, but it certainly does appear that everyone is alive to localization and the need for it. There are some challenges, for sure, about capacity building, the sustainability of the capacity that you create when you create localization, the availability of the right skill sets in particular sectors in order to achieve this. There also came across, I think, there is a willingness, I think, of government or the awarding authority to be practical about what must be required. So we saw it in South Africa in the renewable program. They called it economic development obligations. Just be aware, sometimes they come along in a different name, and it won't be called localization. But again, the South African approach was that you had to tender based on the economic development obligations, ownership, management, control, support of local services, communities. And then there were points allocated to that if they were the successful bidder. You then had to monitor and report. I take on board it cannot be, the administrative process can't be that burdensome that you can't get on with your project. And then you would have a point system attached to that. Yep. And the point system would then be allocated, and at the end of a 12-month period, the points would be wiped clean, and you would start again on zero for the following year. However, you could face monetary penalties, and it's quite a good way to get people focused if there's a monetary penalty. And again, if that just escalates, then it becomes burdensome, and there's too many of these things.